Paragraph 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Elements. 1. A person is performing a lawful act. 2. With due care. 3. He causes an injury to another by mere accident. 4. Without fault or intention of causing it. The person must be performing a lawful act while defending himself against the unjustified assault upon his person made by his assailant. Appellant Galagak fired his revolver at random, wounding 2 innocent persons. Held. The discharge of a firearm in such a thickly populated place in the city of Manila being prohibited and penalized by Article 155 of the Revised Penal Code. Appellant Galagak was not performing a lawful act when he accidentally hit and wounded Marina Ramos and Alfonso Ramos. Hence, the exempting circumstance provided for in Article 12, Paragraph 4, of the Revised Penal Code, cannot be properly invoked by Appellant Galagak. People v. Galagak, 54 Aug. 1027. Striking another with a gun in self-defense, even if it fired and seriously injured the assailant, is a lawful act. When the defendant drew his gun and with it struck the deceased after the latter had given him a fist blow on the shoulder, the defendant was performing a lawful act. The striking with the gun was a legitimate act of self-defense. But we might ask, was the striking done with due care as required by the second element for exemption? We believe so, since the striking could not have been done in any other manner except how it was done so by the appellant. Whether the gun was cocked or uncocked, the striking could not have been done in any other manner. The injury, therefore, that resulted from the firing of the gun was caused by accident and without any fault or intention on the part of defendant in causing it, in accordance with the third and fourth requisites. The trial court puts much stress on the fact that since the appellant allegedly had his finger on the trigger with the gun already cocked, it was reckless and imprudent of him to have used the gun in striking the deceased. We do not agree. Under the circumstances, striking him, as was done here, and not shooting him, was the more prudent and reasonable thing to do, whether the gun was cocked or uncocked. People v. Vitug, 8 California Representative 905. People v. Shinko, California, 63 Aug. 3610. But the act of drawing a weapon in the course of a quarrel, not being in self-defense, is unlawful. It is light threat. Article 285, Paragraph 1, Revised Penal Code. And there is no room for the invocation of accident as a ground for exemption. People v. Rata, Jr., 13 California Representative 1190. The person performing a lawful act must do so with due care, without fault or negligence. Appellant claims exemption from criminal liability under Article 12, Paragraph 4, of the Revised Penal Code, which provides that any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of doing it is exempted from criminal liability. But This exempting circumstance cannot be applied to the appellant, because its application presupposes that there is no fault or negligence on the part of the person performing the lawful act with due care, whereas, in this case, the prosecution had duly established that the appellant was guilty of negligence. People v. San Juan, California, 65 Aug. 11264. Examples of accident. U.S. v. Tejito, 15 Phil. 196. Facts. The accused, while hunting, saw wild chickens and fired a shot. The slug, after hitting a wild chicken, recoiled and struck the tenant who was a relative of the accused. The man who was injured died. Held. If life is taken by misfortune or accident, while the actor is in the performance of a lawful act executed with due care and without intention of doing harm, there is no criminal liability. There is no question that the accused was engaged in the performance of a lawful act when the accident occurred. He was not negligent or at fault, because the deceased was not in the direction at which the accused fired his gun. It was not foreseeable that the slug would recoil after hitting the wild chicken. A chauffeur, while driving his automobile on the proper side of the road at a moderate speed and with due diligence, suddenly and unexpectedly saw a man in front of his vehicle coming from the sidewalk and crossing the street without any warning that he would do so. Because it was not physically possible to avoid hitting him, the said chauffeur ran over the man with his car. It was held that he was not criminally liable, it being a mere accident. U.S. v. Teong Tong, 21 Phil. 476. Just as the truck then being driven by the accused was passing the slow-moving road roller, a boy about 10 or 12 years of age jumped from the step of the sideboard of the road roller directly in front of the truck, and was knocked down, ran over and instantly killed. The accused was acquitted of all criminal liability arising out of the unfortunate accident which resulted in the death of the boy. U.S. v. Knight, 26 Phil. 216. What is an accident? An accident is something that happens outside the sway of our will, and although it comes about through some act of our will, lies beyond the bounds of humanly foreseeable consequences. If the consequences are plainly foreseeable, it will be a case of negligence. Accident presupposes lack of intention to commit the wrong done. The exempting circumstance of art. 12(4) of the Revised Penal Code refers to purely accidental cases where there was absolutely no intention to commit the wrong done. It contemplates a situation where a person is in the act of doing something legal, exercising due care, diligence and prudence, but in the process produces harm or injury to someone or something not in the least in the mind of the actor, an accidental result flowing out of a legal act. People v. Gatella, 17K, 2 seconds, 1047, 1055. Case of negligence, not accident. As the two persons fighting paid him no attention, the defendant drew a .45 caliber pistol and shot twice in the air. The bout continued, However,